Hello everyone, welcome to La Minds. This is Vanaja Bhumireddy. In this video, I am going to discuss about the concept of liability. And the next one is what is meant by liability. First, we need to know that law lays down rights on the individual. Also, rights and duties are correlatives. It means that there is a right, definitely there is a duty. Right of one is the duty of others. For example, I have the right to life and there is a corresponding duty on others to respect my life and do not cause any harm to me. If anybody violates the legal right of another, he is said to have committed wrong, and if there is a wrong, there is a liability. Thus, liability is the condition of the person who has committed wrong. Liability is a responsibility or a obligation of person or persons. Liability arises when wrong is done, or in other words, the law is violated. I will give you an example for this. If A has taken loan from B, then it is liability of A to repay the loan. And I will give you another example. If A is traveling by bus, then there is a liability to purchase ticket. I have already discussed about the liability, and there are some important definitions for liability. According to Salman, liability or the responsibility is the bond of necessity that exists between the wrongdoer and the remedy of the wrong. And the next definition was given by Austin. He used the term impunity to liability. According to him, those certain forbearance, commission, or acts, together with such of their consequences as it was the purpose of the duties to avert, are imputable to the person who had furthermore omitted or acted. According to Mark By, liability is a condition of person who has duty to perform. And the next topic is kinds of liability. Liability is classified into five types. They are: the first one is civil liability or remedial liability, second one is criminal liability or penal liability, third one is vicarious liability, and fourth one is absolute liability, and the last one is strict liability. First of all, I want to discuss about the civil liability. Civil liability arises when civil, that means private rights, are violated. It is also known as remedial liability. It enforces the right of plaintiff against the defendant. The examples of civil liability are recovery of the debt, registration of property. The remedy of the civil liability is based upon the maxim, that is, ubi jus ibi remedium, which means when there is a right, there is a remedy. If an injury caused by the violation of right, the same can be remedied by compelling the person bound to compel with it. The exceptions of the civil liability are an imperfect obligation or duty, unenforceable duties, impossibility of performance by law. And the second one is criminal liability. Criminal liability arises in criminal proceedings. It is also known as penal liability. It enforces the criminal law and punishes the wrongdoer or offender. It is based upon the maxim actual non facit trium. Nisi means sit rea is the basis of criminal liability. It means that act itself does not constitute crime unless done with a guilty mind. Mere physical act without criminal intention is not a crime. Thus, physical act is the material condition and mens rea is the formal condition of penal liability. The example of criminal liability is if A kills B with intentionally, then A is responsible for criminal liability. There are four stages of commission of offense. The first one is intention, second one is preparation, third one is attempt, and fourth one is completion. Punishment theory of criminal liability are deterrent, preventive, retributive, and reformative theories. The exceptions of criminal liability are accident, mistake, intoxication, consent, and etc., which are constituted under Section 76 to 106 of Indian Penal Code. The third one is vicarious liability. Generally, a person is responsible for the wrongs committed by him. However, in certain cases, a person is liable for the wrong committed by another person. This kind of liability is known as vicarious liability. It is based upon the principle called qui facit per alim facit per se. It means who does an act through another is deemed to be done by himself. The examples of vicarious liability are: parents are liable for the wrongs done by their children, master is liable for the wrongs done by his servant, servant is liable because he has done wrongful act, but master is liable because of the master servant relationship. The famous case law for vicarious liability is Cassidy versus Ministry of Health. In this case, the plaintiff's hand had become disabled, invalid during post-operation treatment given by House of Surgeon and other staff. The hospital was held liable because of vicarious liability. And the fourth one is absolute liability. Compulsory liability is called absolute liability. According to the doctrine of absolute liability, when a person keeps or collects dangerous things and they escape even without his fault or negligence and cause damage to the neighbor, such person is made liable in damages to the victim. It has no exceptions. Defendant cannot escape liability in spite of taking all reasonable care. It arises from the breach of an absolute duty. It is not necessary for the injured party to prove any intention or negligence on the part of the wrongdoer. The famous case law for absolute liability is MC Mehta versus Union of India. In this case, oleum gas leaked from the Sriram food and fertilizer industries on 4th and 12th December of 1985. Several persons died and injured. It has been held that owner of dangerous products had a social duty to compensate, to protect the people from danger, and liable without exception. Therefore, the defendants were held liable because of absolute liability. And another famous case law is Bhopal gas case, that is Union Carbide Corporation versus Union of India. On 2nd December 1984, methyl isocyanate gas was leaked from Union Carbide Corporation in Bhopal. 3,000 persons were died and 6 lakh persons suffered permanently disability. Supreme Court ordered to pay 750 crores to the victims. It has been held that the defendants were absolute liable and not subject to any exceptions. And the last one is strict liability. Generally, a man is responsible for his negligence which causes harm to others. But strict liability is an exception to this general rule. According to the doctrine of strict liability, a person is held liable irrespective of negligence or carefulness. Mens rea is not necessary for the application of the rule of strict liability. Liability without fault is called strict liability. There are the wrongs which arises from the breach of an absolute duty. An absolute duty is one which renders a man liable without fault of his and irrespective of any consideration of intention or negligence on his part. The famous case law for strict liability is Ryland versus Fletcher. The defendant is strictly liable without any fault or negligence. He is liable not because of his fault but for keeping some dangerous things in his land, which results damage. In this case, the defendant constructed a reservoir through independent contractors on his own land to provide water to his mill. The engineer failed to seal the old disused shaft. When the reservoir was filled with water, it burst through shaft and flooded the plaintiff's coal mines. Even though the defendant was not negligent and also not aware of the negligence of the engineers, the court ordered him to pay compensation under the strict liability. Salmon divided strict liability into three heads. The first one is mistake of law. It is based upon the maxim that is ignorantia juris non excused. It means ignorance of law is no excuse. It is based upon the presumption that everyone knows the law. No one can say that he did not know the law. Every person must know the law relating to his act or conduct. Mistake of law cannot be pleaded as valid defense. Therefore, the wrongs committed under mistake of law are strictly punishable. And the second one is mistake of fact. It is based upon the maxim that is ignorantia facit excused, which means ignorance of fact is an excuse. Law justifies a wrongful act committed under good faith or innocent belief. Mistake with good intention is excusable, but mistake with bad intention is not excusable. It is excusable only when there is no mens rea. Ignorance or mistake may be due to lack of knowledge or wrong opinion or decision. And the third one is inevitable accident. Unavoidable accidents is called inevitable accident. An accident occurs suddenly which cannot be avoided in spite of reasonable care is taken. It is neither intended nor foreseen. It cannot be prevented by human skill or foresight. An accident may be culpable or inevitable. Inevitable accident is recognized as a defense both under civil and criminal law. Every unintentional act is done either accidentally or by mistake. And the next topic is conditions for imposing liability. There are four conditions. The first one is wrongful act, second one is mens rea, third one is legal damage, and fourth one is direct consequences. Finally, I want to conclude that liability as every act, whatever of man which causes damage to another, obliges him by whose fault the damage occurred to repair it. Everyone is responsible not only for the damage which he has caused by his own act, but also for that which he causes by his negligence or imprudence. I hope that you guys are understand the concept of liability. Thank you.